Actually, intestate succession is very simple. It is much simpler than testamentary succession. As long as you just remember certain important points, which I will presently tell you. Number one, preference between lines. The direct descending line is preferred over the direct ascending. The direct ascending line, on the other hand, is preferred over the collateral line. That is the reason why, if there are legitimate children and descendants, the legitimate parents and other ascendants are excluded. If there are no children and descendants, but there are parents and ascendants together with the brothers and sisters of the deceased, the parents and ascendants exclude the brothers and sisters who are merely collateral relatives. That's the rule of preference between lines. You also remember the rule of proximity. The nearer relative excludes the more distant ones. Kung mas malapit ka, you exclude those who are farther from the decedent. The rule of proximity, however, must always yield to the order of intestate succession. Kahit na mas malapit ka, kung mayroong mas mataas ang ranggo sa iyo sa order of intestate succession, sorry ka. So, we should remember the order of intestate succession. There are two, the regular order and the irregular order. In the regular order, which is the one you apply if the person who died is a legitimate person. Ang number one dyan is legitimate children and descendants. In the irregular order, ang number one, the same. Legitimate children and descendants. Punta muna tayo sa number 4. In both regular and irregular order, sa number 4, you always find the surviving spouse. Again, in number 5, the same. Brothers and sisters, nephews and nieces. The irregular order is shorter by one number. After the brothers and sisters, nephews and nieces, ang sunod na dyan sa irregular order is the state. In the regular order, ang number 6 dyan, other collateral relatives within the 5th degree. Number 7 lang dyan ang state. In the regular order, in position number 2, you have the legitimate parents and ascendants. In position number 3, you have the illegitimate children and other descendants. Itong parents and illegitimate children, magkabaliktad ang tayo sa irregular order. In position number 2, in the irregular order, you have the illegitimate children and descendants. And in position number 3, you have the illegitimate parents. Please take note, parents lang. Only the illegitimate parents are considered legal heirs if the person who died is an illegitimate person. The other ascendants are not considered as legal heirs. Same rule, sinabi ko na in legitim. Doon sa pataas, kung ang namatay ay illegitimate, doon sa linyang pataas, direct ascending line, hanggang illegitimate parents lang ang successional rights, whether it's legitim or intestacy. Some of these heirs can concur, pwede magsabay. Some of them exclude each other. The legitimate children and other descendants exclude the legitimate parents and other ascendants. But they do not exclude number 3, the illegitimate children as well as the surviving spouse. Pwede magsabay yung surviving spouse, illegitimate children, legitimate children. The surviving spouse does not exclude the brothers and sisters. They can concur. Kung ang survivors ay surviving spouse, brothers and sisters, ano hatian? 1/2, 1/2. But the surviving spouse excludes the other collaterals as well as the state. Brothers and sisters, nephews and nieces exclude the other collateral relatives. If you die, you are survived by your brother and by a first cousin, wala, excluded your first cousin. Other collaterals yan. The presence of illegitimate children in the irregular order is enough to exclude the illegitimate parents. If the person who died is an illegitimate person, he is survived by his illegitimate children, his illegitimate parents are excluded. So, some of them can concur, some exclude each other. All right. Ang sabi natin kanina, the rule of proximity yields to the order of succession. Let's assume that X is the decedent. X dies intestate. He is survived by his uncle, U. He is also survived by his two nephews, C and D, the children of his predeceased brothers, A and B. If you count the number of degrees separating U as well as C and D from X, you will notice that they are all 3 degrees away. In the case of C and D, 3 degrees din ang layo. Ordinarily, if you are separated by the same number of degrees from the decedent, you should ordinarily all inherit, share equally. But the fact remains that under the order of intestate succession, C and D belong to category number 5. Nandun sila kasama sa brothers and sisters, nephews and nieces. The uncle, although also a third-degree relative, belongs to category number 6. Mahinang kategorya yan. The presence of number 5 excludes number 6. So, although the uncle is also a third-degree relative, he is excluded by the presence of C and D. Proximity yields to the order of intestate succession. Tandaan natin yung order, ha? Importante yan. Okay. In connection with proximity, we also have to take into account the rules of representation. Why? Because by the right of representation, a further relative becomes just as near. Napapalapit ka if you represent somebody who is closer to the decedent. So what are the important rules of representation? Number 1, there is representation not just in intestate succession, but even in testamentary succession. But in the latter case, representation applies only to the legitimate. There can be representation in testamentary succession only insofar as the legitimate is concerned. If a compulsory heir is given a part of the free portion and he dies ahead of the testator, leaving his own children and descendants, he cannot be represented by his children or descendants insofar as the free portion is concerned. But he can be represented by his children or descendants insofar as his legitimate is concerned. There is representation in testamentary succession only insofar as the legitimate is concerned. Next point. There is representation in the direct descending line, never in the direct ascending line. Your grandfather cannot represent your father. No representation in the direct ascending line. Only in the direct descending line. Next point. There is no representation in the collateral line, except only when nephews and nieces survive with at least one uncle or aunt. That's the only time when there is representation in the collateral line. Next important point. There is no representation in case of repudiation. An heir who repudiates cannot be represented. Basic yan. Kung yung tatay mo nag-repudiate sa inheritance sa iyong lolo, you cannot represent your father. No representation in case of repudiation. However, an heir may represent him whose inheritance he has previously repudiated. Magkaiba yon. An heir who repudiates cannot be represented, but you can represent him whose inheritance you have earlier repudiated. Those are two different things. X dies, survived by A and B's children, and by C, the grandson. B repudiates the inheritance from X. C cannot represent B. Everything will go to A. An heir who repudiates cannot be represented. Let's assume, however, that B predeceased X. Naunang namatay itong si B kay X. And when B died, C repudiated the inheritance from B. Sabi niya, I don't want to inherit from your father B. So he repudiated the inheritance from B. Later on, his grandfather dies. Can C represent B insofar as the inheritance to X is concerned? The answer is yes. An heir can represent him whose inheritance he has earlier repudiated. Next point. Very important. If the person to be represented is legitimate, the representative must also be legitimate. If the person to be represented is illegitimate, the representative may be legitimate or illegitimate. Either can represent. Let's assume that X has two children, A, legitimate, B, illegitimate. A has two children of his own, C, who is legitimate, and D, who is illegitimate. B has two children, E, who is legitimate, and F, who is illegitimate. A and B both died ahead of X. When X died, he was survived by C, D, E, and F. Question, who can inherit by representation in this case? In the case of A, only C can represent him because A is legitimate. Kailangan ang representative niya also legitimate. What about D? Hindi pwede. For one thing, you have the barrier between legitimates and illegitimates under Article 992. An illegitimate child cannot inherit ab intestato from the legitimate children of the relatives of his parent. Neither can those relatives inherit from him. There is supposed to be a barrier between legitimates and illegitimates. Hindi pwede si D. In the case of E and F, they can both represent B because B is himself illegitimate. So, E and F can both represent B. There is no barrier. E and F can both represent B. But even in the exercise of the right of representation, wag nating kalimutan, the ratio of 2:1 should always be observed between legitimates and illegitimates. So, 2:1 ang ratio nila. If B is supposed to receive 30,000, 20,000 will go to E, while F will only get 10,000. The ratio of 2:1 between legitimates and illegitimates should always be maintained. Next point, grandchildren always inherit by right of representation, except if all of the children repudiate. That's the only time when grandchildren can inherit in their own right. Yun lang. Applying the provisions of Article 969. That's the only time when grandchildren can inherit in their own right. If all of the children repudiated, lahat ng anak nag-repudiate, ang natira puro mga apo, applying Article 969, they are the next in degree, they will inherit in their own right, not by right of representation. And therefore, the distribution will be not per stirpes, but per capita. I have earlier mentioned Article 992, barrier between legitimates and illegitimates. And we know the reason for that. There is supposed to be animosity between the legitimates and illegitimates. The legitimates are supposed to look down on the illegitimates as the product of sin, while the illegitimates are supposed to look with envy on the legitimates. Fortunately, this supposed animosity between legitimates and illegitimates, at present, I can see that this is not very well pronounced in our society now. There is a greater acceptance of illegitimates. After all, as I always maintain, it has always been repeatedly stressed, there are actually no illegitimate children. There are only illegitimate parents. Walang kasalanan ng mga anak dyan. Okay? Hindi nila kasalanan. Hindi naman sila nabili. They were not given the opportunity to select the circumstances under which they would be brought into this world. Wala silang kasalanan dyan. But anyway, we still have Article 992 up to now. Nandiyan pa rin yan. So, they cannot inherit ab intestato from each other. Yung illegitimate children cannot inherit from the legitimate relatives. The legitimate relatives cannot inherit from the illegitimate children. The barrier applies only in intestate succession. If you have a half-brother who is illegitimate, there is nothing which will prevent you from instituting your illegitimate half-brother as an heir. There is no barrier in testamentary succession. The barrier applies only in intestate succession. You also be careful about that case of De La Merced versus De La Merced. In that case, something like this happened. There were brothers and sisters. One of them had an illegitimate son. This sibling died. Of course, when he died, who would have inherited from him? Yung mga kapatid niya, B, C, and D. Later on, sumunod ito, namatay. Upon the death of B, his son was claiming his entire estate. Sabi ng mga ibang kapatid, aba, teka muna, yung mga properties na yan, karamihan niyang galing kay A. You are illegitimate. You cannot inherit those properties. Would they be correct? Applying Article 992. They are not correct. Instead, what should apply here is our favorite article, 777. From the moment of death of A, successional rights were transmitted to B, C, and D. When B died, therefore, those properties which he inherited from A were already his own properties. S is not inheriting from the legitimate relatives of his father B. S is inheriting from his own illegitimate parent B. He is clearly entitled to inherit. That's the case of De La Merced versus De La Merced. Intestate shares. You have to know what are the shares of the legal heirs depending upon the combination of survivors. So again, rule of thumb, the legitimates always get 1/2. Basta may legitimates dyan, 1/2 yan. Whether they be legitimate children or kung walang legitimate children, kung may legitimate parents and ascendants, 1/2. Basta legitimate, 1/2. So, if the survivors are legitimate parents, illegitimate children, and surviving spouse, legitims, 1/2 do sa legitimate parents, 1/4 to the illegitimate children, 1/4 to the surviving spouse. If the survivors are the surviving spouse and the brothers and sisters, nephews and nieces, 1/2, 1/2. Basta sa intestate succession, walang matitira, ha? Unlike in the case of legitims. Alright. One legitimate child surviving with the surviving spouse. Isa lang. Settled na yan. 1/2, 1/2. 1/2 to the spouse, 1/2 to the legitimate child. Illegitimate children surviving with the surviving spouse. 1/2, 1/2 din yan. Illegitimate children get 1/2. Surviving spouse would get the other half. Legitimate children, illegitimate children, and surviving spouse. Ano ang shares niyan? You have two theories, yung concurrence and exclusion. If legitimate children survive together with illegitimate children, you either follow but I would suggest you follow the theory of concurrence. Let's assume that X dies survived by two legitimate children, A and B, and two illegitimates, C and D. The estate is 120,000 pesos. X dies intestate. All right. Whether it's concurrence or exclusion, the safe thing for you to do is to first give them their legitims. Always make sure that the legitim is not impaired. Whatever happens, kailangan at least makuha ang legitim. Di ba alam natin? Between legitimates and illegitimates, ang ratio niyan is 2:1. But I would advise against it. Do not apply that ratio directly. Why? If you apply it directly, there is a possibility that the legitim of the legitimates might be impaired. Kung halimbawa, sangkatutak ang illegitimates, 2, 2 lang ang legitimates, halimbawa, 10 ang illegitimates. If you apply that ratio 2:1 directly, chances are may impair ang legitim ng legitimates. So, to make sure that there is no impairment of legitims, first give them their legitims. So, legitim of the legitimate children. Basta legitimate, anong sabi natin? 1/2. Okay, 1/2 of 120. 60, that means A and B are each entitled to 30,000 by way of legitim. C and D, under the family code, legitim, 1/2 of that of a legitimate child. So, 15 and 15. Meron kang matitira na 30,000. Okay? This is where concurrence and exclusion would vary. Under the exclusion theory, the 30,000 should go to A and B, to the exclusion of C and D. Bakit? Because they are first in the order of intestate succession. So, under the exclusion theory, the 30,000 will be divided between A and B. So, A gets plus 15, B gets plus 15. Under the concurrence theory, the 30,000 will be spread out among all four of them following the proportion of 2:2:1:1. So, 2:2:1:1. That's 4, 5, 6. So, 1/6 of 30,000 or 5,000 would go to D, 5,000 would go to C, and 10,000 each would go to A and B. Therefore, A and B will end up with 40,000 each. C and D will end up with 20,000 pesos each. Note that the ratio of 2:1 is maintained. That's the concurrence theory. And I submit that's the better theory because it takes into account the ratio of 2:1, which is established by law between legitimates and illegitimates. Pagdating sa adopted children, just treat the adopted child just like a legitimate child. Okay. Another point which I want to stress would be the problem of partial intestacy, mixed succession. Let's assume that X dies with a will. There is only one provision in that will. He said in that will, I give 10,000 pesos to my friend Mr. M. All right. That's the only provision. So, he dies with an estate of 120. He is survived by his parents, A and B, his wife, W, and his two illegitimate children, C and D. Okay? So, legitimate parents, illegitimate children, and surviving spouse. Yan ang survivors. Obviously, we now have here a case of mixed succession. Why? Because while he had a will, the will did not dispose of the entire estate. So, what's the rule? With respect to the part of the estate not disposed of by will, anong sabi ng civil code dyan? Intestate succession. Alright. The estate is 120. Kung wala itong legacy na 10,000, alam natin ang distribution yan. 1/2, 60,000 would go to A and B. 1/4, 30,000 to C and D. And another 1/4 will go to W. Ang problema, mayroong legacy. Saan natin kukunin yung legacy na yan? From whose share do we get that? Remember the rule. In a situation such as this, you get the legacy, you satisfy the legacy by deducting it from the intestate share of the legal heir whose intestate share is bigger than his legitim. Isa-isa natin. The legitim of A and B is how much? 1/2. Their intestate share is how much? 1/2 din. Hindi natin pwedeng bawasan because A and B are entitled to nothing less than 1/2 of 120,000. Hindi natin pwedeng gawin na we deduct 10,000 from 120, tapos yung natitira, yung 110,000, 1/2, 1/4, 1/4. Mali yun. Because their legitim is 1/2 of 120. Anything less than that would amount to an impairment of the legitim. So we cannot touch the intestate share of A and B. Let's go to the illegitimate children. Their legitim is 1/4 or 30,000. Their intestate share is also 1/4, 30,000 din. Hindi pwedeng bawasan. Let's go to W. The legitim of W is only 1/8. Remember, legitimate parents, illegitimate children, surviving spouse. Legitim of the surviving spouse, only 1/8. So, the legitim of W is only 1/8. The intestate share of W is, however, not just 1/8. It is 1/4 or 30,000. Her intestate share is only 15,000. If we deduct the 10,000 legacy from her intestate share, less 10,000, ilan ang matitira sa kanya? 20,000. That is still more than her legitim. So, that's how we should satisfy that legacy. Do natin ibawas sa intestate share ni W without impairing her legitim. After her legitim is only 15, if we deduct 10,000 from her intestate share of 30, there would still be 20,000 pesos left. And that 20,000 is still more than her legitim of 15. All right. Remember again the rule of double share for full-blood collaterals. Full-blood brothers and sisters, as well as full-blood nephews and nieces, get double, twice as much as that of the half-blood brothers and sisters and half-blood nephews and nieces. Remember that the rule of double share for full-blood collaterals applies only to brothers and sisters and to nephews and nieces. It does not apply to other collateral relatives. It does not apply to grandnephews and grandnieces. It does not apply to first cousins. Okay? Wala na yan. There is no distinction between full and half-blood pagdating sa kanila. Hanggang nephews and nieces lang. Brothers and sisters, nephews and nieces.